Good afternoon. Welcome to the Environmental Advisory Council meeting for May 5th. We're going to start the meeting at 1:02 p.m. Hi, Mark. My name is Dawn Hager-Nordblom. I'm the chair of the Environmental Environmental Advisory Committee. And if the members could go around and introduce themselves, and then ERP staff and Mary Alice, please. Michelle or Rachel or Mark.
Hi, Michelle Lefebvre, member of the council and also exemption committee chair on Big Island.
Hi, I'm Mark. Hi, I'm Mark Gordon, Environmental Advisory Council, and also on the Big Island.
And good afternoon. I'm Rachel Sprague. I'm one of the advisory council members. I am calling from the island of Lanai.
Okay, great. And then Mary Alice, would you like to introduce yourself as well as ERP staff?
Yes, I'm Mary Alice Evans. I'm the director of the Office of Planning and Sustainable Development and ERP staff.
Thank you.
Paul Meisen, the planner with the Environmental Review Program. And we have Daniel.
Yes, I'm Daniel Fedham, a member of ERP staff.
Hi, I'm Isabel Schultz, and I'm OPSD staff.
Thank you. Thanks for putting on the meeting. And then we have members of the public. If I see Emma, Zachary, Kelly Ann, and David Sakota. So if you would like to introduce yourself and describe like why you're here for this meeting, which agenda item?
Aloha, I'm Emma Ewan. I'm with the Department of Land and Natural Resources. We're going to be talking about our exemption list, and I'll pass it to Zach.
Hello, Zachary King, DLNR DOFA on the island of Oahu.
Aloha, David Sakota. I'm with the Division of Aquatic Resources, here to help answer any questions.
Hi, Kellyanne Kobayashi, also with the Division of Aquatic Resources at DLNR, and just, here to support if there are any questions.
Great, thank you so much. Okay, we're going to go with item number 1, which we've done, sorry. We're going to go with item number 2, which is the adoption of the minutes. If somebody, has everyone looked at the minutes and reviewed them, and does anyone have any comments on them? Oh, I'm sorry. We are taking this a little bit out of order. So I should say we're going item 1 and then item number 3, the minutes, and then we're going to go to item number 4, and then we'll go back to item number 2. So Mark, Michelle, Rachel, did you have any questions about the minutes? No. Okay, I just had one minor edit. I believe Kylie Cruz from Earth Justice was the member of the public and item number 7. And I just wanted to make sure that her name is on there so that, it's for the record. Kylie, are you okay with that?
Yes, and then there are others in attendance by Zoom. I don't know if they're reflected as well, but that was Renee Umberger as well as Ashley Aubrey from Native Hawaiian Legal Corporation.
Yeah, their names are mentioned in the public that were present, but
Great.
if you think that you want them specifically in a specific agenda item, we can certainly rearrange that and put their names on there as well for the record.
Yeah, they testified on the same item that I testified on.
Okay. Is everyone? Go ahead, Michelle.
That Kylie's name is misspelled in the notes. If it's correct, Kylie, on your Zoom, it's Kylie. It's spelled Kiley in the notes. Should it be Kylie?
Yes, it's correct in my Zoom identifier here, Kylie, and no N in the Wager.
Do you want Kylie Wagner Cruz or just Kylie Cruz?
Oh, it doesn't matter, but if it's Wager, it has no N.
Okay.
Thank you.
Yes, thank you. Okay, so
then I move to approve the notes with the correction of the spelling.
Great, thank you.
Kylie's
Any
name.
seconds?
Second.
Great, thank you. Any discussion? I don't think so. Yeah, we just had discussion. Okay. Okay, so now we're gonna jump to
Gotta
item
do,
number.
if to vote on it.
Oh, sorry. Everyone
All
who
those in
voted
favor, yeah.
in favor. I assume we all vote in favor. Thank you. Okay, all in favor. Okay, so we're gonna go to item number 4, exemptions committee. Michelle?
Yeah, thanks. The only list on the agenda for this meeting and the only list that we are in the process of reviewing right now is the DLNR revised exemption list. We received DLNR's response to comments, but on Friday. So it was not provided in time for us to include as part of this meeting's agenda. And then we received the revised list on Monday this week. Again, we weren't able to attach it to this meeting's agenda. So I propose that now that we have those files, that we can attach them, since we have them greater than 70s, for the next month's agenda. So I guess checking with the council if you're okay to defer this item until next month, where we can attach all of the supplemental material.
I'm fine with that. Rachel, I'm not sure if you had questions or comments, or Mark.
No.
You're okay with deferring to next?
Yeah, it's for Antoinette, yeah.
Okay. That way, I feel that, you know, everyone will be able to see DLNR's comments as well. Because they came in later. Yeah. Emma, are you all right with that?
Yeah, I'm fine with it. I guess we're curious about the process going forward. The situation is we basically took one of the things that the testifiers had proposed or had objected about, and just made it back to the original exemption list that was in 2020. And then on another item, we did not propose to make changes from our list from the past, and basically gave a justification to the testifiers about why we want to make those changes. So I wasn't sure whether, if we have this slightly revised list, are you guys going to put it out to public comment again? Do we kind of start all over, or is the next meeting potentially the final concurrence meeting? Just curious what we can expect.
Yeah, I think that if just because we haven't had a chance yet to sort of dig in to see whether the changes are substantial, it sounds like reverting back and to the original list is not a major change, but I mean, it does seem prudent to sort of give the public another opportunity to comment. I guess I'd like ERP's opinion on that. Tom, do you have an opinion? I don't think I've been through as chair where we've gone back out with the list. So
it's happened both ways. When changes, sometimes they're considered, I guess, notable enough to get more comment, and sometimes the council says it's okay, it's a minor adjustment and doesn't need to go. So it's essentially a call that the council has. And this is apparently reverting back to what it currently is. So I guess trying to consider where that fits in the spectrum.
I guess I wouldn't feel comfortable making that call today, just because the rest of the council hasn't had a chance to review that and weigh in. But yeah, those would be our two options at the next meeting, whether we would concur with the edits as they've been, have a discussion and then resulting in concurrence, or potentially saying, okay, well, we see these changes have been made to the list, and I think the best option is for us to go back out for public comment.
Yeah. And one other thing I just wanted to put out there is that I did want to just apologize. We weren't able to come to the last month's meeting. We didn't know until very late in the game that was going to be on the agenda. So I wanted to let Kylie and the rest of the people who might be watching this recording know that we actually did watch the recording from last meeting, saw the testimony. And I know it was like, oh, where's DLNR? But we were unfortunately double booked, so couldn't make it. But we were definitely hearing you folks, and also available to chat offline as well if you want to talk about our letters. So I did want to just put that out to any of the people that are testifying. We're happy to talk, and yeah, so that's all. Thank you.
I appreciate that, Emma. And I think at the end of the day, we all want to be very transparent on the process. And, you know, we want to be able to have Sierra Club, Earth Justice, Renee Umberger, and DAR, you know, because they're the ones who really got targeted on those letters. But I think there are other comments that may come up in the next meeting from other members. And so giving us a chance to take a look at the comments from DLNR would be really helpful and for us. It's my dog.
Yeah.
I appreciate that.
David, do you have something?
Sorry, I just wanted to ask, do you know when the next meeting is scheduled for?
It's usually the first Tuesday of the month, although we will set that at the end of this meeting. So that would put us
June 2nd. Yeah, June 2nd, right? Yeah.
Okay, yeah, that should work for us.
And we will, we'll let you guys know. We did send that email out as soon as, when we have the agenda set. But yeah, we'll let you know if it's different from June 2nd. Otherwise, it'll be June 2nd. And the way the council has worked is as long as we're in the process of reviewing an exemption list, we've kept it on the agenda. But we definitely we weren't taking action at the last meeting because we hadn't received DLNR's comments, but folks from the public came, so we definitely heard the input that if you weren't taking action, or I guess to be more clear in the agenda. So we did try to be a little more clear in the agenda this time, so folks that did comment, and so DLNR would know also what stage we were at in the process. Okay. Kylie, I see your hand up.
I just wanted to clarify that Zachary King did email me, the Sierra Club, NHLC, and Renee Umberger a response letter to our comments on the proposed exemption list. The one piece we haven't seen is what the new list looks like. So because everyone's here and folks are short on time, I do have a couple of comments, and I also appreciate Emma's offer to talk offline about this too. But since we're all here, I had a couple of things to say if you want to open the item up for testimony.
Okay, so I think that concludes item 4 then, Dawn, and then we can go to the public comments.
Yeah, do you mind, Kylie, if I just want to make sure, because the agenda is a little different this time. So we have public comments on agenda items, which is item number 2. So do you mind if I close this item and then we'll just open up item number 2 and then you can provide some testimony? Is that okay?
Sounds great. Thank you.
Okay. So thank you, Michelle, for explaining everything for exemptions committee for DLNR. Is anyone have any other comments on item number 4? Otherwise, I'll close it and we'll move to item number 2. Okay, we'll go to item. Oh, go ahead.
Just I guess a comment in response to the new list. I believe it's published on OPSD's website.
Actually, it has not. It was on there, but it was not fully looked at. So I think that it's not on there right now. The new list that you're talking about, is that right?
I understand it's still being reviewed for ADA compliance.
Oh, okay.
Yeah.
So
Yeah.
Once it's ADA compliant.
Yeah, because it wasn't sent out and it wasn't on the agenda. So I haven't seen the new list either, right? It hasn't been sent out to the members. Yeah, so yeah.
We assure that it's publishable, then we'll get it on our website.
Yeah, the problem is, David, with OIP, our other state agency, your other state agency, they're very particular about ADA compliance at this point. So, unfortunately, when things come in a little bit later, it's harder to push it all out on time. So.
Do you know if the federal extension to next year applies to you folks? Because
Yes,
we got
it
an
does.
extension.
It does, David.
Okay, but you're still enforcing compliance right now?
Well, we're told by OIP to do compliance. So
Okay.
I'm not sure if you and Mary Alice are talking about something
Oh,
other.
different types of compliance.
Yeah. Okay.
The
Sorry.
So the ADA accessibility compliance was delayed by a year. And but this office would prefer to have all of the submissions meet the DCAB checklist for accessibility. But the other compliance with OIP is that I believe they now require that meeting materials must be available to the public 3 days prior to the board meeting.
Thank you for that clarification. That helps.
You. And I did have one thing. Michelle, did you want to go over the time, like when everything needs to come in by, just since we're going through this in exemptions committee right now?
Yeah, for future, yeah, it needs to be
Yeah.
7 days. That's when the agenda has to get published. So if we're going to have links, it needs to be 7 days before the meeting, and then to distribute among the board, 3 days is what to be part of the board packet before the meeting.
Thank you. Okay, does anyone else have any comments, questions on item number 4? No? Okay, I'm going to move to item number 2, public comments on agenda items. And Kylie, I think you wanted to do some comments for the DLNR list, so I'll just open it up to you.
Thank you so much for the opportunity to testify. My name is Kylie Wager Cruz, and I'm an attorney with Earth Justice. I wanted to clarify with respect to DAR's response to our comments on proposed exemption, item number 4. I'm sorry, it's type 4, part 1, number 21. My understanding from from DLNR's response letter is that they're not planning on making any changes based on our comments. And I wanted to highlight that the really big change happened when DLNR proposed to move the exemption from type 1, which applied to operations and management maintenance, to type 4, which applies to minor alterations in conditions of land, water, or vegetation. And this is a huge change because DLNR could arguably try to use the exemption to cover extractive activities that alter land, water, and vegetation, including aquarium collection and water diversions. It wouldn't just apply to O&M anymore. And so what we were asking for is that the exemption be clarified to apply only to non-extractive activities. DLNR's response letter does say that they want to keep it the way it is because of there might be extractive T&C practices that they'd want to have exempted, but DLNR's proposed exemption list already includes separate exemptions for T&C practices under types 1, types 4, and types 5, and we don't have any problem with those. So really what we're asking for is for DLNR to either put the exemption back under type 1, which applies to operations and management and wouldn't apply to extractive activities like aquarium collection or water diversions, or clarify that the exemption only applies to non-extractive activities. With respect to proposed exemption type 8, part 1, number 6 through 10, my understanding is that DLNR is proposing to move those exemptions back under type 1, which applies again to operations and management. So they're addressing the fit problem that we raised last time around, that it wasn't really a administrative type of activity like buying pencils and staplers. But there still is an overbreadth problem because at its core, HEPA is designed to apply to use of state lands. That's a primary HEPA trigger. And so it seems really overbroad to exempt all types of land use transactions. DLNR argued in its response that HEPA isn't triggered until the lands are actually used. So you could grant rights to the land, but then HEPA would be done later when you'd actually propose to use the land. That doesn't really make sense to me. If you look at proposed exemption type 8, part 1, number 9, this one could arguably apply to reissuing military leases for state lands. And so it wouldn't make sense to even issue a lease to the military and then do HEPA afterward because the military would have no need or desire for a lease unless they could actually use the land for military training. Um, and so we're certainly open to continuing the discussion with DLNR. We appreciate their efforts to go through this exemption process, which is really important. I know they have a lot of priorities in mind that they are trying to help ease the administrative burden for themselves on a lot of great work that they're trying to accomplish. And as an advocate who's been working on community issues for over a decade now, we're just looking at this from the perspective of how it could affect our ongoing campaigns and have unintended consequences. And so we think that there is some progress here, but there's still work to be done to make the exemption list comply with HEPA. Thank you very much.
Thank you. Zachary, Emma, Kelly, Ann, David, would any of you like to add anything or respond? Or in general, just add comments?
Yeah, I guess I'll let Dar talk about the extractive one, the type 1 to type 4 issue. I think that's more of a DAR issue, but just from my perspective in Division of Forest and Wildlife, it's not just TNC permits. We issue things like letting people pick wood products or fruit from our orchards and all these sorts of things that are very kind of small scale and we think could be covered. So yeah, that's kind of DOFA's piece. I did want to just say that for the issue of the administrative actions that we had classified, such as, buying land, easements, those kinds of things, what we definitely do consider them within HEPA. We're not saying that they're outside of it. The whole purpose of us putting them in the exemption list means that we consider them, as something that is being subject to the HEPA, but we're saying we think that it's justifiable to put them in the exemption list because we believe that the actual act of doing that, of like buying the land or the different various things that are listed, these subdivisions, all these sorts of things, itself is not something that we believe should have an environmental assessment done. That's because we believe that the subsequent use of the land, whether it be for military training or whatever else is being proposed, that action also should be should be looked at. And if it's on the exemption list, we might have the ability to exempt it. But if it's not on the exemption list, like we have to build a road or something, then that would trigger having to do an EA. So we're trying to avoid the situation, like I had, a situation recently where we had to make a subdivision to be able to plant some native trees in Kohala, and the planting of the native trees was exempt. But if actually doing the subdivision is something that's not exempt, we would have to do a whole EA for this process, which we're trying to avoid. So, there's all these sorts of ways that we don't want to bog down good conservation projects. And we also, in some cases, we're doing the subdivision or land acquisition without knowing very specifically what is going to happen with that particular piece of land as well. Sometimes we just buy land without a plans. So, or a very specific plan. So it's also something that doesn't necessarily comport well with doing an environmental assessment where we wouldn't really have anything to say, like, we're going to buy this land, but we want your comments on, almost no content. So, it also is scary to me to potentially not exempt, land acquisition, because if we're required to do an EA for all the land acquisitions that we do, we're already often touch and go with making these deals. And these are really good, important conservation deals. And so we then throwing an EA requirement in the mix would be very difficult for us. So those are some of the things that we're kind of balancing as well. Thank you.
Thank you. Kylie or Rochelle, go ahead.
Am I allowed to ask a question?
No.
Yeah.
Yeah. Okay. So I'm that all makes sense. Thanks, Emma, for that. I'm trying to think about sort of Kylie and the other pieces of public testimony on sort of the flip side of that. So like, what are the safeguards, especially when it's a part one exemption where it doesn't, like because there's part two, right, which still wouldn't require an EA, but would require an EA exemption notice to be published to at least notify the public. I'm trying to think about what protects from the other way of that. You have good intentions with it. Is the way it's written and the way the law is written protect conservation land or other land from being transferred out of a protected status into like the Department of Agriculture or Department of Transportation or termination of an easement or that kind of thing? Because I'm just trying to think about how the exemptions can be worded such that they do reduce the administrative burden on, like you said, things that you're not quite sure what's going to happen with it yet, or sort of those more routine things with the way that it's written. And I'm not a HEPA expert, but where you could read it that it's almost contradicting the statutes trigger the way that the statute is written and the way that how to protect it from essentially having no or very little review sort of in the more harmful direction.
Well,
And
yeah.
maybe that's not, I don't want to put you on the spot. Maybe that's not a question for you, but if you do have thoughts or as just again as something to think about.
We definitely think about that all the time because we're very much conservationists at heart and don't want to open up a Pandora's box either. And the thing that we kind of go back to is just that, again, let's take your example of like the military land leases or the converting, conservation land to, ag use or whatever, is potentially negatively going to affect the environment and wanting to do a review of that. I think that if we need to make sure that those actions itself are not exempt, but the administrative action, like subdivisions or purchasing the land, things that are just someone signs a piece of paper and it is done, rather than like they're actually like doing stuff on the ground. We still think that that is not something that needs to go through the EA process and would be a good like candidate for being on the exemption list. But don't like say, oh yeah, we can exempt something like turning a forest into pasture land or ag land or homes or whatever, those kinds of things. It's not really something that actually DLNR often does. Like you might want to review like the Department of Ag's and Biosecurity's list, because they would be the ones receiving the lands and then converting them, that sort of thing. But from like we do lease out lands to the military. That's something that DLNR does, and so avoiding the those types of land uses on the exemption list, I think, is the way to have those sideboards.
Yeah, I think I was just thinking about it that like sometimes it's hard to once a transfer is done or once the administrative action is done, that can sometimes be hard. Like conservation easements are in a good way, but those are in perpetuity. Though most of them do have termination options, and just sometimes it's like once the land use has changed. In some cases, it might be somewhat irreversible, like that once the land use has changed, now the rules have changed. And so something might no longer be against, or it might no longer need quite the review. I don't know. And yeah, I think my hesitation with this one is just the sort of the breadth and openness of those like land changes without really any sideboards on them. Again, just with that acknowledgement that sometimes like a title transfer or a land sale is not particularly like what happens afterwards is at that point the ship has sort of sailed. In some cases, and again, but trying to think about how to not, because like how to not put roadblocks up in front of you folks now.
I think I know it's the public testimony part, but I think I just want to interject two things from the regulation perspective, in that one, that an exemption, right, is not an exemption from HEPA; it's an exemption from preparing an EA. So when something falls under the different exemption types, again, it doesn't pull it out of the 343 process. It's just Tom's got a great flow chart, or ERP's got a great flow chart that shows where we are in that process. So, but to your point, right? I mean, the public isn't notified if it's a part one. Rachel, that part is true. So if it was a part two, then there would at least be the notification that the agency is pursuing an exemption for a certain action. And provides, I know Tom said it many times in different presentations, but right, gives the agency some level of legal protection since you've got a 120-day challenge period, right, from discovery, Tom, on exemptions, right? If it's been published in as a part two exemption, right, then the public has 120 days from that point to challenge it, as opposed to some point down the line, if it's not published as a part two, but the action is taken as a part one, then that discovery can happen sometime down the line, and sort of then you've got 120 days from that discovery point. So there's some protection there from the agency, I think, as well, for certain activities to be a part two for that reason. And then my second point was, what was my second point? Oh, one thing we talk about a lot in exemptions is that we've got the general types, but certainly an action doesn't have to be on a list to be exempt, right? If it falls within the category, it doesn't have to be spelled out for the agency to take, for it to feel that a certain activity falls under one of the exemption categories. Certainly, I think, to everybody's benefit, for the list to be as useful and as detailed as possible, or as detailed as possible to be useful. But certainly it's not required that it be spelled out in the list in order to claim an exemption, so long as that activity falls under the general type as spelled out by the rules. That's all.
Thanks, Michelle. Mark, do you have any comments or any
No, not really on it. Yeah, I'm picking a lot of this up, as you know, Dawn, since I haven't been with you for a while. I mean, it's interesting.
Yes.
And yeah, I'm listening, especially that you guys are sharing about, the different lists and the different types. So yeah, no, I don't have additional comments. Thank you.
Yes, I appreciate that. So, just my thoughts is that, of course, we have more drought and climate change, and, some of these, what I find sometimes is the rules and the statutes aren't always addressing what's going on in the real world, right? But what I do know is that, DLNR usually will partner with all their agencies so that hopefully if somebody is doing a type 1 or type 2, activity, that the general public would know. So I'm hoping that at the next meeting, that DLNR and Sierra Club and Native Hawaiian Legal Corp and Renee Umberger will have had that time to discuss any further issues. And then at the next meeting, we can try to really open it up and have the discussion and see if, there'll be concurrence on the list or not. So that's my 3 thoughts right there. Okay, so no other comments, David or Kellyanne or Zachary?
I can add like real briefly. I think the question is for us for the exemption type 4. It's not whether it's extractive or non-extractive, because there could be non-extractive activities that have more than a negligible impact, and if we would decide based on the case by case application whether an exemption declaration is appropriate or an EA, and likewise for extractive activities, we would weigh that on a case by case basis. So it would help. Like Emma said, it's not all traditional cultural practices. There's other activities that may not fall within that, that we do permit for, like some of our like restoration permits, fish pond restocking, things like that. That when we get applications, we run it by our biologists and ask them, like, is the amount that they're asking for going to have a impact, or if we do feel like it will have more than a negligible impact, usually what we do is we reduce the amount that we allow them to take, but alternatively we could ask them to do the EA, but usually we prefer to issue an exemption declaration but just reduce the amount. So that's the I guess my comment is, like, it's not black and white. It's like, and we review it on a case by case basis. And so having that authority for extractive uses is helpful for us. Thank you.
Thank you. And I think Michelle had mentioned this last meeting that if the list is concurred or not concurred, it's still DLNR's list. And if it's really not on the Environmental Advisory Council to be, I don't know, the rule maker, I guess, the Native Hawaiian Legal Corp and Sierra Club would be really talking to DLNR and hopefully coordinating with DLNR, whether they approve or accept of, the permits. But Environmental Advisory Council is really advisory in our capability, since our responsibilities got, changed a little bit. So Michelle, if I'm stating that incorrectly, please let me know.
Okay.
Correct. Okay. All right. So any other comments? Otherwise, I'll close item number 2 and
Dawn, I have one more comment to David.
Sure.
David, when you mentioned you looked at some different projects and you said your agency looks and sees if some are the effect is negligible. How is that determined? Is there anything quantitative, or does an agency determine? I mean, I could look at something. I'm looking, for I look a lot, with the DOH and the air branch with air emissions. So, I could say something's negligible, whereas DOH, clean air, could say it's not. So how does your agency deal with what you consider negligible? Is there anything quantitative with that?
I don't know if we have anything like in writing, but we look at um, you know, the organism or the resource that is requested to be taken. We look at the life history, how abundant is it, how fast does it reproduce, where do they want to collect from a sensitive area or spread out collection. So there's nothing like that spells out like exactly what a threshold would be, but
Yeah,
we review it internally and we come to a position within our division within DAR on what's acceptable that we, in our expert opinion, believe won't have more than a negligible impact.
I see. Now, if you guys determine something's negligible on it, David, does the public, can the public respond and say, or some other agencies say that we don't consider it negligible, we disagree with your determination?
All of the SAPs we issue, we've been publishing the exemption list, and I don't know of any that we've received comments on. I know some of the SAPs we bring to the board, we like for issuance of the permit, there's challenges to that, and the board has denied some permits on that basis. But in terms of the ones that DAR issues without bringing to the board, I don't know of any examples. There may be, but I can check with staff.
Okay, yeah, just curious. All right, well, thank you. Appreciate it. Thanks for the information.
Go ahead.
Sorry, just to flesh that out a little bit. So we do see the exemption list. Those are available through the environmental notice. And then there is the opportunity to challenge an exemption. But once an exemption is issued, you have to go to court pretty quickly, and it's really, really hard to get an action to stop from proceeding. Once you're in court, it's usually the agency can go ahead and authorize the activity anyway, even though there's a lawsuit. And so what we're trying to do is just create narrowing principles to ensure that these exemptions can't be used for known hot button issues that have impacts like aquarium collection, military leases, TMT. There are a whole host of things out there that have had environmental review in the past, and we're just concerned that this proposed new exemption list could change that paradigm to the detriment of the public.
Thank you. Okay, any other comments? No. Okay, great. We'll close item number 2. And then for those of you who are still going to remain on the meeting, we're going to go to item number 5, review of the Department of Business, Economic Development and Tourism, repeal of Chapter 11-200.1, and adoption of Chapter 15-20 Hawaii Administrative Rules. So thank you all from the other items. If you want to stay on and listen to the DBED proposed rule changes, please feel free. We'd also love comment from any of your agencies as well. So at the end of the day, we all have to work together. Okay, so Tom, I'll let you take it away. Or is it Mary Alice? Sorry.
Thank you, Chair. I'll take that one. The Environmental Review Program staff is continuing to try to align the changes made in Act 152 SLH 2021 with by making housekeeping changes to what is currently Chapter 11.200.1, which is basically within the Department of Health's sequence, shifting it to Chapter 15, which is the DBED sequence for Hawaii Administrative Rules. And now that the program has moved over from Department of Health to DBED, and also putting the changes in that the legislature already made a decision on, and then looking for any areas that in the August 2019 rule update might have generated some questions about clarity, and in the time since then, which has been 7 years. But we do not have a draft ready for consideration, and so we'll defer that, Chair, to future meetings.
Yep.
Thank you.
All right. Thank you. Does anyone have any comments for Mary Alice regarding the DBED rules? Mark? No? Okay.
No.
All right.
Mhm.
I'll close item number 5, and I don't think there's anyone here from the general public, but I guess we'll do announcements. Item number 6. So I think the next meeting will be, if I'm looking at the calendar, June 2nd at 1 to 3 p.m. Is that okay for everyone?
Mhm.
Okay. And then we do have another, so the agenda did change a little bit. So we had public comments on agenda items and then just regular public comments, which I actually did like because I feel like everyone really stuck to the agenda item that they needed to discuss. Anyway, we have public comments, but I don't see anyone from the general public, so I will close that. And then I think we'll adjourn the meeting. So thank you.